Good evening and welcome to the launch of Volume 47, Issue 1 of the University of New South Wales Law Journal. On behalf of the journal, I would like to begin by acknowledging the Gadigal people of the Eora Nation, the traditional custodians on the land on which we gather this evening. We pay our respects to their elders, past, present and emerging, and extend that respect to all Aboriginal and Torres Strait Islander peoples joining us tonight. My name is Sharanya Murthy, and I am the Executive Editor of the University of New South Wales Law Journal for 2024. It is my privilege to commence tonight's official proceedings for the launch of Volume 47, Issue 1. Tonight's launch would not be possible without the generous support of Premier Sponsor Herbert Smith Freehills. Herbert Smith Freehills has supported the journal for over 40 years, going as far back as 1982, and has been vital in establishing and maintaining the journal's status as one of Australia's leading academic law reviews. My sincere thanks to Naomi Fianet for making tonight possible, and Brooke Massender, the Global Head of Pro Bono at Herbert Smith Freehills, whom we are more than delighted to have speaking on behalf of the firm later tonight. I would also like to recognise the journal's other premier sponsors, Allens, Course Chambers Westgarth and King & Wood Mallisons, for their invaluable support. One of the defining features of the UNSW Law Journal, aside from its entirely student-run body, is its analysis and confrontation of topical issues at the forefront of the legal world, shaping discussions in academia, policy, and lawmaking. Analysis and confrontation so significant that it landed the journal 2 citations in a highly public federal court decision published yesterday. Issue 47.1 is no exception to this excellence, containing 10 articles that explore a plethora of legal topics. From international child protection laws to pseudo-law and sovereign citizens, the breadth of themes captured by Issue 47.1 truly highlights the journal's commitment to analysis and investigation of modern legal issues. I would like to extend my thanks to all the authors featured in Issue 47.1, some of whom are here tonight, for entrusting the journal with their scholarly works and for contributing to discourse on critical legal issues. In responding to such a comprehensive and contemporary issue, I would like to welcome and thank Mr. Alastair Lawrie, the Director of Policy and Advocacy at the Public Interest Advocacy Centre. With more than 2 decades' experience in public policy, including advocating for reform of the Anti-Discrimination Act and addressing the Religious Discrimination Bill, Mr. Lawrie joins us tonight to deliver a keynote address on the topic of decoding life, freedoms, and governance. As I mentioned earlier, another hallmark of the UNSW Law Journal is its entirely student-run body. What makes me so proud to be a part of this fantastic publication is the camaraderie and genuine enthusiasm with which each and every single member of the editorial board here tonight has given for the publication of this issue. My thanks as well to the rest of the executive committee, currently consisting of 4 issue editors, 1 forum editor, and 1 digital editor. Running a journal truly is like a team sport, and without the remarkable knowledge, good humour, and grace of our athletes, being every editor here tonight, this journal would fall rapidly into disrepair. Special thanks must also go to our digital editor, Rachel Luo, for the hidden work that she's put into getting us all here tonight. And of course, this issue would not exist without the exceptional Jessie Liu, editor of Issue 47.1. Jessie has been tirelessly dedicated to the production of this issue, literally working around the clock to see it brought to life, something we found out after seeing emails being prepared in the very early hours of the morning. The editorial board is incredibly proud of Jessie, and I hope everyone can see Jessie's passion for the journal manifest on all 348 pages of this issue. I know when I say that Jessie's thoughtfulness, diligence, and remarkably useful IT skills will be sorely missed by the executive committee. The editorial board is sad to see Jessie go, but are pleased to welcome her successor, Fiona Shah, who has already proven that she is up for the challenge. Last, but definitely not least, I would like to thank the UNSW Faculty of Law and Justice, particularly our two brilliant faculty advisors, Rosalind Dixon and Gary Edmond, for their sage guidance and support, and Professor Andrew Lynch, Dean of UNSW Law and Justice, who is here tonight and has already shown his avid advocacy for the journal this year. It is now my pleasure to invite Brooke Massender, the Global Head of Pro Bono at Herbert Smith Freehills, to speak on behalf of the firm.
Thanks so much, Sharanya, and welcome everybody. It's great to see you all here, and especially some familiar, friendly faces. As has been mentioned, I'm the Global Head of Pro Bono at Herbert Smith Freehills and a partner in the firm, and I'm particularly excited to be here for this launch this evening. I'm also going to start by acknowledging the traditional owners of the land on which we meet tonight, the Gadigal people of the Eora Nation, and I'd like to pay my personal respects and the respects of the firm to elders past and present. So the relationship we have with UNSW is really long-standing, and at the risk of stealing some of Andrew's material for later, in my day job, typically we're engaging with possibly Kingsford Legal Centre or the Indigenous Legal Centre, and it's really lovely tonight to be here in the context of the Law Journal. I noted the comment that it's been around for 40 years, which is a very long time. It sounds like pretty much the time I was starting primary school, so just to give that a little bit of additional context. The launch topic is really interesting, decoding life, freedoms and governance. And again, without straying into territory that I know that Alastair will cover, there were a few little sort of gems that really resonated for myself and the pro bono team at HSF as we looked through the myriad of topics that were discussed, because they're very similar to the things that cross our desks and that we aim to support on a day-to-day basis. So one that really struck the mark for me was the criminalisation of race and class through fines, and in the context of the work that we do with the Shopfront Youth Legal Centre, we see that all the time. Similarly, in the governance section, the interrelationship between family violence, economic abuse and commercial directorships is something that we're seeing increasingly in that context. So almost every other topic we could sort of see, we do see in the practical manifestation. So delighted to welcome you all. Very much looking forward to hearing from Alastair, who, as Shiranya said, is the Director of Policy and Advocacy at PIAC, which is another organisation very dear to our hearts. And I was going to say that even before I saw the CEO here as well. And so I think all that's left for me to do is to introduce and congratulate Jessie and the whole team behind this issue, which I very much look forward to reading. Thank you.
Thank you, Brooke and Shiranya, for opening the night and for the introduction, and I'm really glad that you did enjoy looking through it, because I myself also had a lovely time. I also want to start by acknowledging the traditional owners and custodians of the land on which we meet today, the Gadigal people of the Eora Nation. I pay my respects to their elders, past, present and emerging, and acknowledge any Aboriginal people here today. The land always was and always will be Aboriginal land. To everyone who has taken time out of their Tuesday evening to attend the launch of issue 47.1, I welcome you to join me in unravelling the legal mysteries that the 10 articles of this issue of the UNSW Law Journal spotlight. It's a great honour to have been involved in the workings of one of Australia's leading academic legal journals, and especially one that's entirely produced by a voluntary student board. We pride ourselves in being read and cited by justices of the High Court of Australia, Federal Court of Australia, and the Supreme Court of New South Wales. And in parliamentary reports, Hansard and other law journals and reviews, just to name a few. The journal's dedication to legal academia is also emphasised in being open access, and for anyone who didn't manage to snatch a complimentary copy of the Law Journal, please do head over to our website to see the articles in 47.1 and every issue prior, and I promise you that you'll find something to suit your tastes. 2024 marks the journal's 49th year running, to be precise, and yes, this is your cue to clap, should you wish, of course. Thank you. Thank you. As one of many UNSW law students who has served the journal's student-run editorial process, I am incredibly proud to be standing here today to speak on the adventure that the past year has been leading up to the first issue for this year. As you may already be aware, the theme of this general issue is decoding life, freedoms, and governance, and I'd like to open the discussion by borrowing some words from my predecessor Enrico, the editor of issue 47.1, without whose influence I wouldn't be here today. He doesn't actually know that I've borrowed these words, so I do hope that it's all right with him. In 2023, Enrico said this: "We are a generalist law journal, and with so many human rights issues becoming so pertinent as time goes on, it wouldn't surprise me if human rights would be a plausible theme for any general issue going forward." Wise words, Enrico. Entering into 2024, Human Rights Watch reported renewed hostilities, natural disasters, perpetuated inequalities, and a continued fight for the rights of women and girls, people under the lesbian, gay, bisexual, transgender, queer, intersex, and asexual umbrella, Indigenous people, and children. It is precisely the interpretation of the legal frameworks underlying these various structures that govern life, or their decoding, if you will, that the 25 authors of issue 47.1 dealt to. In a country like Australia, our laws should protect all of us equally. Many of us probably share that sentiment in these opening lines of Equality Australia's recent report on the LGBTQIA+ discrimination in faith-based schools and organisations. 2017 saw the legalisation of marriage between two people rather than only a man and a woman, to the exclusion of all others. And now, the queer community's fight has shifted to the banning of conversion practices, which seek to change or suppress a person's sexual orientation or gender identity. In the first article, Martin Clark and Brendan Gogarty searched the reins and hearts with an analysis of the varying definitions of conversion practices under criminal, mental health, and anti-discrimination law, finding the solution is not in a unified definition, but rather law reform that is mindful of this intersectionality. They argue that the responsibility to distinguish genuine healthcare from pseudoscientific conversion practices remains best left to medical regulatory bodies than the police, prosecutors, and human rights bodies, as has been adopted in Queensland, the Australian Capital Territory, and Victoria. Moving now to the freedom to be free, Sarah Schwartz breaks down the criminalisation of race and class, as was mentioned by Brooke, that is presented in Australia's legal system since colonisation, and how community payment of bail has served as collective resistance to these injustices. Most targets of Australia's criminal justice system experience poverty, homelessness, and other forms of social and economic disadvantage, with First Nations people being 7 times more likely to be charged with a criminal offence than non-Indigenous people. The historic monetisation of these criminal punishment and the subsequent First Nations-led resistance in both the US and Australia prove the significance of bail funds and community payment of fines in facilitating community inputs that disrupt and expose systemic injustice. Focusing now on decoding the legal mysteries for those at an earlier stage of life, Rachel Gregory Wilson, who is here tonight and should be congratulated, Elizabeth Hansley, Liesl Spencer, and Toby Rayburn unravel the best interest of the child and argue how infants, or children under 12 months of age, have distinct needs and should be treated as a discrete category of children under all legal instruments, from the Convention on the Rights of the Child to domestic out-of-home care legislation. Deciphering the laws across those rights for life provide an insightful snapshot, but don't represent the bigger picture. And so we must change the lens from people to focus instead on the structures that govern them. In the 4th article, Vivian Chen walks us through the hidden risks of economic abuse through coerced directorships, where victim survivors become straw directors to bear liability for business failures and Phoenix activity. The focus of regulatory guidance on the pursuit of the true directing minds behind the breaches and the consideration of debt waivers in circumstances of coerced liability are argued as much better solutions to that conundrum. And a similar area of ambiguity is explored in charity law. Ian Murray, Jeanette Jensen, Marco Risley, Robin Carroll, Donovan Castellan, and Natalie Skeed uncover the tendency of charities to treat restricted philanthropic gifts as being conditionally held on private arrangements rather than on the court's commonly preferred construction of a charitable trust. The reasons behind the shift into increased private arrangements and the public interest implications of affording such degrees of power to donors are both covered in the 5th article of this issue. And shifting now from governance to governments in the second half, acts of decoding here stem from the interpretation of laws governing domestic freedoms that lie dormant within the Constitution. David Tan, Tamsin Philippa Page, Despina Hrambanis, and Joseph Green quote 20 of the High Court's 2019 to 2021 judgments to a modified version of Philip Bobbitt's modalities, settling the dominance of doctrinal interpretation and raising insights into the shifts in judicial approach that need to be considered. And now, narrowing in on one of those approaches, the prudential approach, which decides constitutional questions only where necessary to do the justice in the case, Tristan Taylor, who is also here tonight, reveals the High Court's reasons for adopting the prudential approach as an additional protective layer and demystifies the risks of an inconsistent and uncertain application. Lastly, investigations of law must also open at the global level in the final 3 articles of this issue. Hamish MacDonald surveys the international conventions that inform the management of Australia's plant breeder rights, reinforcing the need to protect objectivity when assessing the distinctiveness, uniformity, and stability of new plant varieties. Stephen Gallash and Jeremy Kingsley put forward a similar call to arms in the realm of transnational competition law, directing the focus back to human actors of competition regulation to crack secrets behind the lack of global frictions in the enforcement of divergent domestic law. And last, but very much not least, Harry Hobbs, Stephen Young, and Joe McIntyre close out the legal decoding by debunking pseudo-legal claims from foreign citizens in Australia and Aotearoa, New Zealand, and analyse the evolution and internationalisation of pseudo-law. Now then, reaching the end of both the journal and the journey of decoding life, freedoms, and governance, this detective runs into the problem of still having too many words to say and not enough time to say them. A huge thank you once again to the authors of this issue, from the ones who are here today to the ones who have sent their support from afar. It's been a privilege to work so closely with you all, from peer review to publication, and I will always be grateful for issue 41 for being such a huge chapter in my university career. As always, the journal is immensely grateful for the ongoing support of our premier sponsors, Herbert Smith Freehills, Allens, Cause James Westgarth, and Kingswood and Mallison. And a special shout out to the team at Herbert Smith Freehills and Naomi Fianet for organising this fantastic evening. And a personal thank you for all the time you spent decoding my lengthy emails and allowing me to stand here with confidence today. We will also always remain grateful for the UNSW Law and Justice faculty. Thank you to the members of staff present here today, and a special shout out to my lecturer, Lucas, who has been a highlight of many of our Tuesday afternoons. To our Dean, Professor Andrew Lynch, a thank you from everyone on the Executive Committee for your warm and unwavering support of the Law Journal always. Please know that we all avidly enjoy and take so much pride in every Instagram post or story that mentions us, and we remain very grateful to be backed by a support network that empowers our independence as a student-run journal. Thanks must also be given to those who govern the journal's aesthetics, including our amazing typesetter, Kerry Cook, our cover designer, John Hewitt, the amazing printing team at Laguerre, and, of course, the excellent editors of the board who dedicate themselves to verifying every rogue pinpoint, scoured libraries of the globe for obscure sources, and also tolerated, deciphered, and perfectly interpreted my instructions in my likewise lengthy emails. I can't say that my application to be an editor of the Law Journal wasn't motivated by a desire to engage in debates about the Oxford comma or capitalisation, just to name a few, but I can say that there wouldn't be a better bunch of brilliant and uplifting people that I could have done this with. To the incredible 2023 Executive Committee of Matilda, Enrico, Hayden, Anna, Jack, Zong, Sarah, and Lucas, thank you for setting a high bar of editorial excellence for us to follow, for the encouragement I wouldn't be here without, and for entertaining my technological innovations. To the 2024 Executive Committee of Sharanya, Brad, Jack, Rowan, Marcella, Rachel, Elizabeth, and Fiona, thank you for embracing a new era of editorial discretion with such grace, for introducing baked goods as a meeting requirement, and for everything you've done so far to launch the journal's 49th year running so strongly. I can't wait to see what new heights you'll soar to. To my friends and loved ones who have supported me as I piece together the puzzle that has formed the book that many of you are holding today, no words are enough to thank you for everything that you've done. But know that I am immensely grateful and unbelievably appreciative of you all. And now, a final thank you for today's guest of honour, Alastair. Alastair is the Director of Policy and Advocacy at the Public Interest Advocacy Centre and has led projects focused on anti-discrimination law reform, including to stop the Morrison government's religious discrimination bill, to protect LGBTQ+ teachers and students in religious schools against discrimination, and to improve New South Wales Anti-Discrimination Act. In addition to having 2 decades of experience in public policy and writing an influential blog that I personally also stumbled onto and enjoyed, Alastair is a long-standing advocate for the lesbian, gay, bisexual, transgender, intersex and queer community and is a board member of the LGBTIQ+ Health Australia in 2010, as well as co-chair of Tennis Australia LGBTQIA+ Advisory Group. Thank you all for your attention in these past few minutes, and please join me in welcoming Alastair.
Thank you for that generous introduction and, of course, for the invitation to speak here tonight. Thank you also for the broad theme of issue 47.1 to address in my remarks, Decoding Life, Freedoms and Governance, which took me several days to decode. I must confess I don't feel particularly qualified to talk in detail on the topic of decoding life, which is something that most people do in consultation with their therapist. I do, however, have plenty to say on the twin and intertwining topics of decoding freedoms and decoding governance, at least partly based on my lived experience. That's because, as a 45-year-old gay man, it has been impossible to avoid thinking about the meaning of freedom, of what I've been free to do or not do or protected from at different stages of my life, and what others, including religious organisations, have been free to do to me, or to deny the role of governance and governments, state and federal, in determining the extent of those freedoms, far too often without consultation with or even consideration of those most affected by their decisions. Indeed, some of the key moments of my life overlap with milestones in the history of LGBTIQ rights in Australia. I was born in July 1978, just weeks after New South Wales Police arrested 53 people for participating in the first Sydney Gay Mardi Gras parade, an indication of how unwelcoming both the law and its enforcement were for LGBTIQ people here. Although I grew up in rural Joh Bjelke-Petersen era Queensland, which was undoubtedly worse. Queensland did not decriminalise male homosexuality between adults until January 1991. But even then, it introduced a differing age of consent for anal intercourse, 18 versus 16 for other sexual acts, a discrepancy that was not abolished until 2016, and with charges and convictions arising because of this inequality still not included in the historical homosexual convictions expungement scheme today. January 1991 was also personally significant for me for a couple of reasons. Just 1 week after decriminalisation, I found myself travelling 800 kilometres from the rural farm that I grew up on to boarding school in Brisbane. Then, on my first day there, I found I was same-gender attracted too. Audience members will be unsurprised to learn that religious schools were lawfully permitted to discriminate against LGBTQ students and teachers in Queensland at that time. Loopholes my school took full advantage of over the following 5 years. While I'll spare you the details tonight, it would be an understatement to describe growing up gay at a religious boarding school which enjoyed special privileges to be prejudiced as horrific. Fast forward to 2008 and to another coincidence. I was employed as a ministerial advisor under the Rudd Labor government. At the same time as I met and began my first de facto relationship with the man who is still my partner today, I ended up providing some advice on the details of Commonwealth same-gender de facto relationship recognition. Some younger members of the crowd may not be aware this recognition did not even exist until 1 July 2009. Then, in January 2010, my partner Steve and I got engaged, meaning I would spend the remainder of my time working for a government which did not fully recognise the legal equality of my own relationship. Despite departing Canberra in mid-2012, I continued to advocate for the introduction of Commonwealth anti-discrimination legislation protections for LGBTIQ people, something that was finally achieved in June 2013, just 10 years ago, but almost 4 decades after race discrimination was prohibited federally, and more than 3 decades after homosexuality was protected in New South Wales, something we'll return to later. The subsequent 4 years were predictably dominated by the subject of marriage equality, not only campaigning for it to be passed, but also debating the manner of its passage, from conscience votes through to the push for the ALP to hold a binding vote, and from successful community efforts to stop the Turnbull Coalition government's plebiscite, to failed attempts to prevent their postal survey. In another coincidence, I started at the Public Interest Advocacy Centre just a couple of months before we helped one of the unsuccessful High Court challengers to block what may have technically been a statistical survey, but was actually an anti-democratic anomaly. I note this challenge fell just prior to the relevant time period for the article, How Does the High Court Interpret the Constitution? A Qualitative Analysis between 2019 to 2021. It would have been interesting to see how Tan, Page, Harambanis and Green characterised that Wilkie decision. In any event, thank you for indulging me in sharing a little of my backstory, which I think reinforces that to be a gay man, or any member of the LGBTI community, in the final 2 decades of the 20th century and the first few of the 21st, is to have been engaged in a constant state of contestation of our legal rights. Our lives have been made inherently political, with participation in the political process rendered essential, even if the state has frequently been the oppressor, or at least acted on the oppressor's side. That background also helps to explain why I am an advocate today, why I chose sexuality-related anti-discrimination law in practice as the topic of my law honours paper at ANU, why I've spent much of the past two decades volunteering for a range of community organisations, including both the Victorian and New South Wales Gay and Lesbian Rights Lobby, and why I've ended up at PIAC, where over the past 7 years I've been fortunate enough to work not just on marriage equality, but also on advocacy against the Morrison government's religious discrimination bills, which presented a grave threat to the rights of LGBTIQ people, as well as women, people with disability, and even people of minority faiths. Above all, I've focused on efforts to secure anti-discrimination protections for LGBTQ students and teachers in religious schools, under both state and federal law, which is obviously a full circle moment given where I started. I intend to use the remainder of this speech to talk about what LGBTIQ rights look like in New South Wales today, across 4 key issues: conversion practices, birth certificates, medical interventions on intersex children, and anti-discrimination protections. Now, had I given this address a month ago, I would have been able to make the pithy observation that we live in the worst jurisdiction for LGBTIQ laws in Australia. Instead, following passage of the Conversion Practices Ban Act in late March, we've moved all the way up to equal worst with Western Australia. Actually, maybe that's uncharitable. If we're being generous, we might even be able to say that we're second worst just. From an advocate's perspective, the passage of this legislation is both welcome and long overdue. It will legally prohibit conversion practices defined in Section 3 as a practice, treatment, or sustained effort that is directed to an individual on the basis of the individual's sexual orientation or gender identity, and directed to changing or suppressing the individual's sexual orientation or gender identity. This is needed because, as described in the opening article of 47.1, Martin Clark and Brendan Gogarty's excellent Searching the Reins and Hearts Conversion Practices Reforms in Australia, quote, "Scientific and clinical evidence has consistently shown that there is no evidence that conversion practices are effective in their capacity to effect a change or suppression of sexual orientation or gender identity. There is also consistent evidence that conversion practices carry clear risks of harmful effects on those subjected to them, including physical and psychological harms, such as increased suicidality, self-harm, post-traumatic stress disorders, anxiety and depression, feelings of alienation, loneliness and exclusion, sexual dysfunction, substance abuse, internalised homophobia and feelings of failure, and reluctance to seek medical treatment," end quote. Disappointingly to Clark and Gogarty, who argue against a carceral approach, the new Act implements both a criminal offence and civil complaint scheme for conversion practices, although I must respectfully disagree with them. Given the seriousness of the harms they outline, I would suggest criminal penalties for the worst examples are appropriate. Either way, the passage of this law is a testament to the advocacy of conversion practices survivors like Anthony Van Brown, Chris Chabbs, and Nathan Despot over many decades. But I would not be honouring their work without also highlighting their primary criticism of the law as passed, that unlike the best practice scheme in Victoria, the New South Wales law does not provide a formal mechanism for third-party complaints to Anti-Discrimination New South Wales. As it stands, the only complaints that can be made are from survivors directly or via representative complaints with the consent of each survivor. This framework not only reinforces one of the limitations of anti-discrimination law generally, that the onus for seeking redress falls on the people who have been mistreated, it ignores the particular characteristics of conversion practices, where the people undergoing them appear to do so voluntarily, despite what, as Martin and Gogarty note, is the impossibility of genuine consent in these circumstances, and are therefore unlikely to bring or consent to complaints until after they have extricated themselves from those practices, if they survive them. The lack of third-party complaints is a major gap in the scheme that must be rectified. The Act also includes a range of carve-outs, providing that activities like clinically appropriate healthcare, stating what relevant religious teachings are or what a religion says about a specific topic, and parents discussing matters relating to sexual orientation, gender identity, sexual activity or religion with their children do not constitute conversion practices. Despite this, a number of conservative religious organisations campaigned against the law in its totality, alleging it constituted an attack on religious freedom. I must, perhaps a little less respectfully this time, disagree with them too. There is no philosophical justification for the right to inflict serious psychological harm on children and young people in the misused name of religious freedom. Even in the case of adults, where there at least is a possible argument for the freedom to engage in practices which may result in self-harm, I would submit there is a clear justification for government regulation. This is because of what Clark and Godey describe as the role played by conversion ideology as a precursor to conversion practices. Quote, "Survivor advocates have consistently contended that conversion ideology, the worldview that it is possible and necessary for LGBTQA+ people to change their sexual orientation and gender identity, and that being LGBTQA+ is due to trauma, spiritual brokenness, and can be fixed by prayer, is central to defining and understanding conversion practices because the inculcation of these beliefs in congregants is important for smoothing the path for them taking part in actual conversion practices." End quote. In other words, perpetrators of conversion practices first convince healthy people to believe their sexual orientation or gender identity is somehow sick when it is not, before offering a cure that actually causes more harm. The law should not protect the freedom to engage in this abuse. Before I conclude on this subject, I feel compelled to express my condemnation of the role played by the Liberal National Coalition during parliamentary consideration of this law, and especially of their vote in favour of minor party amendments to remove gender identity from any protection under the Conversion Practices Ban Act. In other words, the New South Wales opposition voted for the continued legality of practices, treatments or sustained efforts to stop trans people, and especially trans young people, from being trans. This was a shameful act, and one I would strongly urge them to reconsider in relation to future LGBTIQ law reform, including on the next topic we will turn to. That topic is birth certificate legislation, and in particular, the regulation of access by trans and gender diverse people to identity documents reflecting who they are. Sadly, the New South Wales Births, Deaths and Marriages Registration Act, 1995, is unequivocally the worst such law in the nation. We are the only jurisdiction which still requires people to undergo genital surgery before being able to update their birth certificates, surgery many trans people do not wish to undertake, and of those that do, many cannot afford because of a lack of Medicare funding. While we are only one of only two jurisdictions alongside Western Australia with no legislative options for sex or gender markers beyond male or female, non-binary people cannot access state-issued ID stating they are, in fact, non-binary. These laws aren't just an insult to the human dignity of trans and gender diverse people. The requirement for surgery, which causes sterilisation, is a denial of reproductive freedom and therefore the right to found a family. While the inability of many trans and gender diverse people to access birth certificates reflecting who they are at all means they are confronted by the possibility of outing in the growing range of scenarios where ID is mandated. Fortunately, the Equalities Legislation Amendment LGBTIQA+ Bill 2023, introduced by the independent member for Sydney, Alex Greenwich, and currently being considered by a parliamentary inquiry, would address these problems and at least bring New South Wales law up to the standard of Victoria and Queensland. We urge both the New South Wales Government and opposition to support it. Turning to the third topic I flagged earlier, and in which New South Wales law is manifestly deficient, medical interventions on intersex children. For audience members new to this subject, intersex people have innate sex characteristics that do not fit medical norms for female or male bodies. It is estimated somewhere up to 1.7% of children are born with these variations of sex characteristics. Tragically, the medical system's response to many intersex children is to perform so-called normalising surgeries on them. These interventions are often not clinically necessary for the child's health, but instead performed for non-therapeutic or psychosocial reasons, including to assuage the disappointment of parents who expected their child's body to conform to societal norms, or to assist the child to fulfill gendered stereotypes in the future. For those curious about what that means in practice, I suggest reading the 2016 family court case of Rikala, which ruled that a family can consent to the sterilisation of their 5-year-old child without court approval, without clear medical necessity, and at least partly motivated by gendered expectations, including attitudes to that young child's potential future sexuality. It was then, and remains today, a genuinely heartbreaking decision. These unnecessary surgeries are obviously done without the consent of the person affected by them, who should be free to agree or not agree to them when they have at least reached Gillick competency and understand what is involved. In my view, medical interventions on intersex children, which are a fundamental denial of bodily autonomy, are one of the gravest human rights violations happening in Australia today, not just in relation to the LGBTIQ community, but across society. There have been multiple public inquiries recommending these practices be ended, including the 2013 Senate inquiry into the involuntary or coerced sterilisation of intersex people in Australia, and the Australian Human Rights Commission's 2021 report, Ensuring Health and Bodily Integrity towards a Human Rights Approach for People Born with Variations in Sex Characteristics. Sadly, however, only one Australian jurisdiction has so far passed legislation to prohibit these surgeries, the ACT, while I understand Victoria may be close to finalising their laws. In contrast, there is no New South Wales Government commitment to introducing equivalent laws here, nor was it included in Mr Greenwich's Equality Bill. This is a gross failure of governments in New South Wales and elsewhere to protect the rights of the most vulnerable. It is unsurprising I had this issue front of mind while reading the article Out of Home Care, Contact Orders and Infant Mental Health, recognising a unique developmental stage in law, policy and practice by Rachel Gregory Wilson, Elizabeth Hansley, Liesl Spencer and Toby Rayburn, including their observation that, quote, infancy is therefore a special and critically important stage of human development, and infants as a class of persons require special recognition and safeguards, including under child protection law. Infants are not little children, just as children are not little adults. They need different and unique exposures in their environments to facilitate optimum physical growth and emotional development, end quote. While I made this observation in a different context, I think it reasonable to apply these principles to intersex children, who deserve legislative safeguards for their bodily autonomy, and who should be allowed to grow and develop free from unnecessary medical interventions to try to change their bodies into what society expects them to be. Let intersex kids be free from surgeries performed according to the wants of others rather than their own needs, and only performed following their own timeframes if they so consent. Turning to the final topic of my speech, anti-discrimination coverage. Once again, New South Wales has the worst laws in the country. Nowhere is this more apparent than in the protections the Anti-Discrimination Act 1977 offers, or more accurately fails to offer, LGBTIQ people. It wasn't always this way. In fact, New South Wales was the first Australian jurisdiction to protect lesbians and gay men against discrimination in late 1982. Incidentally, this was before the decriminalisation of homosexuality in mid-1984, meaning there was an 18-month period during which gay men were criminals, but legally could not be denied housing. But the lack of subsequent reform, especially over the last 28 years, has allowed this law to atrophy. We are now the only place nationwide which does not protect bisexual people against discrimination, and one of two with Western Australia that does not protect non-binary people and intersex people. The provisions allowing discrimination by religious schools are the broadest in Australia too. Indeed, they are so broad, they apply to all private educational authorities, not just religious schools, and they offer a complete or blanket privilege to discriminate. Unlike all other jurisdictions, there is no test which New South Wales schools must satisfy before being permitted to discriminate. The Act simply does not apply to them. These serious flaws are just some of the reasons PAC has made comprehensive anti-discrimination law reform a priority, including through our August 2021 report, Leader to Laggard, the case for modernising the New South Wales Anti-Discrimination Act. We were obviously pleased New South Wales Labor listened to that report and made comprehensive review of the ADA and election commitment. And we have welcomed, participated in, and will continue to participate in the current New South Wales Law Reform Commission inquiry into this broken and outdated law. But as people discovered at the start of the century, when the Law Reform Commission completed its last review of this legislation, with its report then gathering dust rather than being implemented, an inquiry is meaningless if nothing subsequently changes. We will continue to advocate to the Minns Labor government until we finally have an Anti-Discrimination Act fit for the 21st century, one offering genuine protection against discrimination for all communities, including LGBTIQ people. Speaking of Law Reform Commission reports at risk of gathering dust, I cannot discuss anti-discrimination law reform tonight without also addressing the current federal situation. As audience members are aware, this issue has been ongoing for several years. Since late 2018, when both the then Morrison government and then Albanese opposition promised to protect LGBTQ students, with Shorten going further in promising to protect LGBTQ teachers too. Labor under Albanese then took these commitments to the May 22 election, with Attorney General Mark Dreyfus referring the question of how they should be implemented to the Australian Law Reform Commission in November that year. The ALRC handed its report to Dreyfus in December. They proposed straightforward amendments to the Sex Discrimination Act and Fair Work Act to reflect the following two principles. One, that LGBTQ young people should enjoy the freedom to learn and to grow without fear of discrimination on the basis of who they are. And two, that LGBTQ teachers should be employed on the basis of their skills and experience rather than their sexual orientation or gender identity. We hoped the privileges for prejudice enjoyed by religious schools might finally end. But when the government released the ALRC report in March, those hopes were immediately dashed, because the Prime Minister indicated no legislation would even be introduced to Parliament without bipartisan support from the now Dutton opposition, effectively abdicating responsibility for his own election promises to the parties he had defeated. Remember, not only did the coalition do nothing to implement Morrison's 2018 promise to protect LGBTQ kids, they withdrew their own religious discrimination bills from Senate consideration because of amendments to prohibit discrimination against trans students. Just today, Shadow Attorney General Michaelia Cash has written an opinion piece, not just opposing reforms to the Sex Discrimination Act, but also backing calls by religious schools for positive rights to discriminate under federal law, with the consequence of overriding protections for LGBTQ teachers and even students in states and territories that have progressive laws. It was abundantly clear to observers when Mr Albanese announced his bipartisan push, and is undeniable now, that there are only two possible outcomes. One, there is no agreement and therefore no protection for LGBTQ students and teachers. Or two, there is agreement, but any bill supported by the coalition will not offer genuine protection for LGBTQ students or teachers. Either way, LGBTIQ Australians lose again. It is hard not to share the sentiments, if not the choice of language, of religious school discrimination survivor James Elliott Watson when he described the impasse thus, quote, "MPs are paid in excess of $200,000, so everybody should do their fucking job. And I think that's especially true for the Leader of the Government and my Prime Minister. The purpose of Parliament is to enact laws that ensure the safety, integrity and protection of Australian citizens, and that's what this is about. It needs to protect vulnerable children from legal discrimination practices that religious organisations are allowed to engage in by changing the law. Let's get it done." End quote. If Albanese doesn't get it done this term, it will be no less of a failure of governance and governments to realise the basic freedoms of LGBTIQ Australians as the failure to achieve marriage equality over many years. Indeed, there are many similarities between these two issues. Both were reforms supported by a large majority of the Australian community. Both could be delivered with legislative ease, following well-established precedents. In the case of marriage equality, overseas examples. In anti-discrimination law, the successful operation of state and territory laws. Both issues had politicians who claimed to support change, but were recalcitrant in delivering it. Significantly, both marriage equality and anti-discrimination reform have seen Prime Ministers impose artificial barriers hindering change. In the former, an unnecessary plebiscite cum postal survey. In the latter, the unnecessary need for bipartisan support. With the result that on both issues, LGBTIQ Australians are made to wait far too long for positive change. Which is the most important point. It is LGBTIQ Australians who suffer real-world harm because of political intransigence. In marriage equality, we remember Peter Bonsall-Boone and Peter de Waal, who were together for 50 years, and in the face of Bond's declining health, desperately pleaded for Malcolm Turnbull to introduce marriage equality so they could finally wed. Bond died 6 months before it was passed. In relation to LGBTQ students, I think about the person whose story we will never get to hear, because the mistreatment they experienced causes them to prematurely end their life. I say that with confidence because that was nearly my story. The horrific discrimination I suffered at the hands of my religious boarding school, which I mentioned earlier, caused me to experience suicide ideation from the second term of Year 8 through the final term of Year 12 and beyond. I am, in many respects, very lucky to still be here. But I am also full of resolve, because that is no way for a child to learn or to grow up. And so I can state with equal confidence that I and PIAC will continue to advocate until no child has to endure the same. As I come to the end of tonight's speech, I'm tempted to apologise for the heaviness of some of the subjects I've spoken about, including the personal impacts of anti-LGBTIQ prejudice. It is an occupational hazard of being an advocate, and especially one who focuses on policy and law reform, to be constantly critical, to highlight where the law is deficient and the terrible outcomes of those shortcomings. I do not intend to convey the impression there has been no positive law reform in my lifetime or since that very first Mardi Gras, not just on conversion practices, but also decriminalisation, de facto and rainbow family rights, and in many other areas. Nor is the plight of LGBTQ people in religious schools intractable. I am reliably informed my own boarding school is now welcoming of same-gender attracted and gender-diverse students, a product of anti-discrimination protections for students that have existed successfully in Queensland for 20 years. But I do mean to impart the understanding that the struggle for the full realisation of LGBTIQ human rights and freedoms in Australia is far from over, and that we will never reach that endpoint without the concerted efforts of the community, both LGBTIQ and non-LGBTIQ alike. I welcome those present tonight as fellow travellers on the long journey ahead. Congratulations on issue 47.1 of the UNSW Law Journal to Jessie, your editorial team, and to all of the authors published. It is truly impressive in its breadth and depth of scholarship. And thank you for listening to my remarks.
Good evening. I'm Andrew Lynch and I'm the Dean of the Faculty of Law and Justice at the University of New South Wales, and my role tonight is to offer a vote of thanks. The vote of thanks is primarily directed to Alastair, of course, who has generously spoken tonight, and I want to begin with him. And Alastair, you said before that you were tempted perhaps to offer an apology for the personal nature of your remarks. And I'm glad that you didn't, because no apology was needed at all. And in fact, the power of your remarks was made even greater by how generously you shared the personal side of your own story, and to both track the milestones of reform alongside events in your own life. And I really want to thank you on behalf of everybody present tonight for the way in which you did that, which really was to open the topic up in a way that made it so very real and connectable to all of us. I also want to thank you for the incredible work that you have been doing at the Public Interest Advocacy Centre. You mentioned, obviously, PIAC's role in the postal vote for marriage equality, an event which was very traumatic and distressing for so many in the Australian community, regardless of the end of that process, and also the work that you've been doing in respect of the religious discrimination bills, a very fractured and fragmented process that has likewise been a flashpoint for many, and upsetting to see the twists and turns of that. So thank you for sharing your personal story. Thank you for the work that you have done. And then finally also, thank you for your address tonight, which shows how much work remains to be done across our federation. The idea of laboratory federalism is one that, as a public lawyer, I often invoke, and as much as it can be a method through which progress is achieved, it can be frustrating to see the inequality that creates across the Australian polity, and the slowness with which progress in one place can actually lead to that in another. And you've reminded us tonight that there is an enormous amount of work to be done, not just in New South Wales, but throughout the country as well. So thank you again for your address in every respect, which was simply magnificent. It seems too good an opportunity to waste to shine a bit of a spotlight on the Public Interest Advocacy Centre and the connection that it has to UNSW, and also the importance of its work generally. And I hope that our students here are familiar with the work of PIAC. The ties are many and varied. Emeritus Professor Andrea Durbach had previously been a director of PIAC before she came to UNSW in 2005. She is now back on the advisory board of PIAC. Colleagues have worked on raising the age for criminal sentencing with PIAC, and also the stop and search powers of New South Wales Police, just to name some examples. So it's great to have not just Alastair, but other staff from the Public Interest Advocacy Centre here tonight. We salute them for their work. It's so important. And we also are very proud to have engaged with them in the past and look forward to doing so in many other areas in the future. So thank you. Of course, I thank our premier sponsor and host tonight, Herbert Smith Freehills, and thank you, Brooke, for your earlier remarks. That's also a very special relationship to the Faculty of Law and Justice. The sponsorship of the journal goes back, we're told, until 1982. The work of Kingsford Legal Centre just simply would not be possible without the support of Freehills, which has provided pro bono solicitors to KLC for over 30 years. It's a really remarkable and special tie between those two. But also, in addition to that, we're very glad that Freehills is a contributing sponsor to the textbook access scheme that has been established just in the last 2 years to support students through their program at UNSW, and also to create professional opportunities and experiences. And also recently, just last year, we inaugurated the Margaret Stone Lecture, which celebrates the life and legacy of a former UNSW academic, Herbert Smith Freehills partner, and Federal Court Judge Margaret Stone. I now want to thank also my colleagues, and particularly Gary Edmond and Rosalind Dixon, for the work they do in supporting the journal, which has been very generously acknowledged tonight, and also to thank other colleagues who have come to show their support. The entire faculty is immensely proud of the UNSW Law Journal. It adds an incredible lustre to our own research efforts and is internationally regarded. And as has been said tonight and is fully recognised, an entirely student-run and independent publication, which makes its success particularly remarkable. The professionalism of the editorial team is second to none. It's great. And now to the journal itself. I always like to bring the physical prop with me. Students often say to me they don't like group work, but the journal is in fact evidence to the contrary, because it is clearly group work in every sense. I want to thank and acknowledge the work of every single member of the editorial team who have chased down every last footnote, full stop. Is it italicised? Is it not italicised? Those are the kind of questions I used to talk about as an editor, as well as the Oxford comma. Everyone who was involved to produce this tonight has done a remarkable job. The miracle always happens. That's right. I turn up and the journal is here. There's lots of late night emails. Will it or will it not be done on time? It always is. So congratulations, but particularly also to the executive team of 2024. And lastly, to Jessie. This is her, it's a team effort. It is group work, but this is Jessie's issue of the journal, and congratulations to her as the special editor. Thank you.
Thank you very much, Professor Lynch, for that vote of thanks, and thank you, Mr. Lawrie, for your sincere, passionate and insightful keynote address. With Volume 47, Issue 1 of the UNSW Law Journal officially launched, we have now reached the conclusion of tonight's proceedings. Please feel free to remain and mingle for the next 20 minutes or so, and please do not forget to collect a complimentary copy of Issue 47.1 if you haven't already. All of the articles of this issue can be found on the UNSW Law Journal's website from tomorrow. Thank you all for your attendance tonight, and I hope you enjoy the rest of your evening.